Hello, everyone.
Hi.
Nice to see you this afternoon, or not necessarily see you. I hope you've all got a nice brew and a sandwich this lunchtime. Um, we were going to just wait for a few others to join. We had quite a few on today. Anyway, we'll just get cracking. I'm sure they can kind of catch up if they come a little bit later. So thank you very much for joining our employment law webinar today. I'm sure that you recognize mine and Lizzie's faces. I think a few of you have been on our webinars before. But just in case you don't, then I am Liz Chiver and I'm the Director of Hallidays HR. And this is my colleague Lizzie Walsh, and she's our HR business partner. So I run Hallidays HR, which is a HR training and recruitment consultancy based in Stockport. We are recording today's webinar, so we can share this with you afterwards. So we'll send an email with it on, and also a copy of the slides as well. We've deactivated your microphones. I know that we don't need you to have your videos on or anything. That's absolutely fine. But if you do have any questions or anything, then by all means, if you want to just put it in the chat function, that's absolutely fine. We'll keep a track of that as we're going on. Okay, so let's have a look at what we're going to cover then in the next 45 minutes or so. So we're going to look at sexual harassment and the law. We're going to look at the increase in those statutory rates, the neonatal leave and pay, and then we're going to look at employment law on the horizon. Okay, so I want to start the webinar just with a bit of a reminder, really, of the change in law last October regarding sexual harassment. So some of you might be aware and may have already taken kind of the necessary action. However, kind of what we're still hearing from a lot of businesses is that they're still unsure of what exactly the obligations are and what they need to do and what those actions that they need to take. So thought it might be quite a good idea to do a bit of a recap of this on this session. So I just want to share some stats with you to begin with. And this just kind of emphasizes why the law changed in the first place. So the Trade Union Congress ran a sexual harassment survey in 2023, and it had the following results. So 58% of women have experienced sexual harassment at work. 62% of women aged 25 to 34 reported sexual harassment. 20% of employees faced physical harassment in the workplace. 13% experienced harassment while socializing with colleagues, and 27% of men reported harassment at work. Okay, so some pretty hefty figures going on there. So just in terms of a bit of a definition of, what is sexual harassment. So the Equality Act 2010 defines it as when a person engages in unwanted behavior of a sexual nature, either verbal, non-verbal, or physical, that creates an intimidating, hostile, degrading, humiliating, or offensive working environment. Okay. And unfortunately, as you can see from this slide, there are quite a number of different examples that could constitute sexual harassment. So, things like sexual gestures, sending sexually explicit text messages or emails, or, even photos and displaying those. Even things, like talking about your sex life and having those conversations. But I think it's important to remember that sexual harassment doesn't have to be intentional. It can occur from, someone of the same sex or of different sex. So I think we have that kind of preconception that it is just, potentially men kind of acting inappropriate to women, and that is absolutely, not the case. It is both ways, and it's with the same sex as well. And also that sexual conduct that was previously welcomed can become unwelcomed at any time and unwanted. So, of course, sexual harassment at work has always been unlawful, and it continues to be the case. However, on the 26th of October last year, changes were introduced to state that employers are now under what we call a mandatory duty to prevent sexual harassment. Okay, so this is the change that took place. And what this means is that this means that you have to take reasonable steps to prevent sexual harassment of your employees in the course of their employment. Okay, so obviously it applies to sexual harassment. It only applies to sexual harassment. So it doesn't apply to harassment based on any of the other protected characteristics. So, not anything to do with race or age or sexual orientation or belief or anything like that. And also it does not apply to harassment, which is related to sex, but is not conduct of a sexual nature. So kind of quite a kind of distinct difference there. But the new duty also extends to sexual harassment occurring in the course of employment. So it's the full course of employment. So, it can also include work-related events. So, potentially works nights out, leaving drinks, conferences, any kind of, anything you have with clients or anything like that. And the duty requires employers to anticipate situations where workers might be exposed to sexual harassment and to take action in advance to prevent that particular harassment from taking place. So that's where we're talking about that whole preventative duty. Okay. But just to go into, I guess, what does it actually mean to have a preventative duty, and what does it look like? So, it's about that proactive action. So employers must take action before incidents of sexual harassment occur. It's about taking reasonable steps. So, you've got to take steps that are reasonable, but this is obviously related to the size of your business, the sector that you're in, and the resources that you have available to you. To risk assess it. So, employers must identify and mitigate any risks of sexual harassment. So this is where the assessment comes in advance. And then to create that action plan. So that's where, employers must develop a plan to address the risks that have been identified, and then to kind of put that plan in place, monitor the effectiveness of any steps taken as well. So, I mean, just to, I guess, go into a little bit more detail about what that might look like, and I guess how we've interpreted it and how we've been kind of helping our clients to kind of navigate this particular area. And kind of, I guess, unhelpfully, the law doesn't stipulate exactly what steps an employer needs to take to kind of prevent sexual harassment. And so that whole kind of what is reasonable is kind of up for negotiation a little bit. But some of the things that we have been doing with our clients is that whole, developing an effective anti-harassment policy. So those of you who are clients of ours, you can kind of rest easy that you already have one of these in your handbooks. It's already sorted and covered. But for those of you that are not clients, then, it's about looking to create a policy that includes who's protected against sexual harassment, what the processes around it are. So, how they report sexual harassment, what sexual harassment looks like, how it will be dealt with. But it'll also include that whole third party harassment as well. So this is, harassment from a third party, an external party. So, not an employee, not a manager, not anyone within the business, but obviously should still be treated just as serious. And you should have, steps in place for preventing this type of harassment as well. It's important to engage your employees. So, you need to ensure that your employees are aware of what the law is and, what the behaviours are that are expected and, what does constitute sexual harassment and how, they can behave themselves, but how to spot it in others. And you need to be very clear on that whole reporting procedure in terms of, if anybody sees it or anyone has experienced it, how do they go about reporting it? And to make sure that they've got access, to those relevant policies, and that they really understand the consequences of breaching those policies. There's obviously the training element of things. So this is, at all levels of the business. It isn't something that's stipulated by law, but, a session for employees, again, in terms of, how to go to report any claims, how it will be handled, they take it seriously, that type of thing, obviously is brilliant. But also from a management point of view, so that, the managers are really equipped in terms of handling claims effectively. And, they're not just kind of brushing anything under the carpet, which I guess leads us on to the next point, which is, taking those complaints seriously. So I know it goes without saying, and, if anybody does kind of come to a manager, as a manager or business owner, that, you will take it seriously, but sometimes, like I say, that it can be kind of brushed under the carpet. And it's just, making sure that steps are followed and those investigations happen and, treating it seriously. It's that whole thing again about the risk assessment. So, identifying circumstances and situations at high risk of harassment and putting plans in place. So, when completing a risk assessment, part of it will relate to kind of analysing those historic claims and you collating information around kind of previous allegations, when and where any kind of allegations of sexual harassment took place, what actually happened, what were the risk factors, or what action have you taken to minimize those risks, and then but also again, like we've said, it's about looking for, are there any patterns that are happening, and reviewing that on a continuous basis. So not kind of just thinking this is a one-time only kind of approach to to kind of managing sexual harassment effectively. It is that ongoing process that needs to be touched base on repeatedly on this. Okay. So that kind of just gives you a little bit of, I guess, a bit more of an understanding on the kind of preventative duty of sexual harassment. I hope that's kind of been useful. Obviously, if you would like any additional support or want to know have any further questions, by all means, let me know or pop them into the chat and we can answer them at the end. If you just to quickly mention, I guess, before we move on, is that in terms of, that training or the policies, like I said, that is something that we could help you with. So, let us know if that is of interest for you. Okay. Next up then is just looking at the statutory rates. So on the 6th of April every year, the statutory rates do go up. So the government are very kind in that way. So just to talk you through what the increases are going to be in a week or so's time. So statutory sick pay is going up to £118.75 per week. And then your maternity, paternity, adoption, shared parental and parental bereavement pay is going up to £187.18 per week. I won't read all of those national minimum wage figures out, but obviously they're on the screen there, and we'll share the slides in terms they're going up as well. And then the lower earnings limit is increasing by £2 to £125 per week. Okay. And also just worth noting here as well that the employer's NI is so the national insurance contributions are increasing to 15% as of April 2, and I'm sure that won't have escaped you either. Okay, so I'm just going to hand over to Lizzie now, who's going to touch on the new neonatal leave and pay, and then the what's on the horizon from an employment law point of view.
Thanks, Liz. So, yeah, the Neonatal Care Leave and Pay Act 2023, I think it's probably gone under the radar a little bit, in all honesty, given all the other employment changes that have been announced in recent months. However, from the 6th of April, so next week, give or take a few days, it will take effect. So allowing employees with babies who are premature or sick after being born and receiving neonatal care that additional time off. So neonatal care leave is a new statutory right that will allow employees to take time off work with their baby when the baby's been admitted into neonatal care, and this is when it's within the first 28 days of them being born, and if they've had a continuous hospital stay of 7 full days or longer. So eligible parents will be able to take up to 12 weeks of leave and receive statutory pay in addition to other leave they may be entitled to, so maternity or paternity. And this will only be applicable while the baby remains in hospital. So parents are eligible to take the leave from day one of their employment, providing immediate access to this type of leave. It can be taken in blocks of a week for each week their baby is in hospital, up to a maximum of 12 weeks. And the leave itself then must be taken within 68 weeks of the baby being born. So in terms of how this will interact with other forms of parental leave, so for example, maternity leave. So employees will need to take their neonatal leave at the end of their maternity leave. So they can add a period of neonatal care onto the end of that leave, therefore extending the amount of paid time off. So how that would work in practice is it could be that employees choose to curtail their maternity leave once the statutory maternity pay ends. So at that 39-week period, they can then move on to neonatal care and pay for the next 12 weeks. So essentially, it would result in nearly a whole year of statutory paid leave. The actual pay side of it, so statutory neonatal care pay, is actually available to those after a qualifying period of service, and that's 26 weeks. So the right to the leave is a day one right, but the right to the statutory pay is after 20 weeks service. And they also have to meet that minimum earnings threshold, which is that £125 a week figure that Liz mentioned earlier. And the statutory rate of pay will either be £187.18 per week or 90% of an employee's average weekly earnings. So whichever is the lowest is what they'll be entitled to be paid. So employees taking the neonatal care leave, they are entitled to receive the same job protections as those provided for other types of family-related leave, such as maternity and paternity. So that includes things like the protection against dismissal, or being at a detriment as a result of them having taken the statutory leave in the first place. So in terms of being able to prepare for this, I guess businesses, obviously, you need a policy with the key details in. If you are a client of ours, don't worry, when we do the handbook updates next month, we'll be incorporating this for you. Obviously, if you are not a client of ours and you need one, then do drop us a message and we can absolutely help you with that. But also it's about, I guess, thinking about the processes for, when somebody requests that leave, what do you need to do? What do you need to kind of think about? Letting payroll know, looking at are they eligible, are they not, sending them some form of letter. So I guess it's just about thinking from an internal perspective how ultimately, those requests for neonatal care leave and pay will be managed. But yeah, that's a new one that's coming in. And actually, as far as we are aware, unless anything kind of changes in the next few days, there aren't actually any other planned employment law changes effective from April this year. So just wanted to take the opportunity to remind you of what is expected in line with the Employment Rights Bill, and there have been some changes to what they had initially proposed, which we're going to talk about. We are still kind of hearing that, autumn 2026 is the time that the majority of changes will take effect. So we don't need to get to panic mode quite yet. There is still plenty of time to get prepared. And of course, we'll keep you updated as and when more information is released. But in terms of the Employment Rights Bill, it was 150 pages long, so there was an awful lot of detail in there. However, in terms of, I guess, the key areas that we've pulled out of that, I guess the biggie that everybody kind of went was this unfair dismissal rights from day one and that need for a statutory probation period. It was that SSP would become available from day one for people, and that flexible working would become the default for all workers, that there was going to be a ban on the use of exploitative zero-hour contracts, further parental and bereavement rights from day one, and then some other changes that you should be aware of. So, as I said, the biggie was this unfair dismissal and this to become a day one right. So, as I'm sure you're aware, currently employees have to be employed for 2 years before they can make a claim to an employment tribunal for unfair dismissal. The change will mean that from day one of their employment, they will have the protection. So the government has confirmed that it is going to introduce a statutory probation period for all new hires. We're hearing that it's potentially going to be a maximum of around 9 months, but the length and the actual specific protections are subject to consultation still. The probation period is likely to soften the blow in terms of managing unsuitable employees out of your business. I think it was this assumption that, if we've got any bad eggs, we'll never be able to get rid of them. That isn't the case. The probation period essentially will still allow you to remove unsuitable employees out of your business, but it'll just mean that there is a process that you have to follow. You will have to have that paper trail and ultimately be able to evidence the decision that you have made. They're also looking at the awards associated with unfair dismissal. So if somebody does win a claim for unfair dismissal, then inevitably I think the award that is they are issued is going to go up, but that's currently being consulted on, so we're not too sure as to how much or indeed when. But what we do believe is that employers will be able to extend the probation period, but again, we don't know what that kind of will look like, and they've talked about this lighter touch, but again, we need more information before obviously we can share it with yourselves. This was the other one that I mentioned, so flexible working to become the default. And I think at first it sounded like, ultimately people would be able to kind of work wherever they wanted, whenever they wanted. But that isn't the case. As we know, flexible working is already a day one right. However, what the government propose is to make flexible working the default wherever practical. So again, what that looks like is still up in the air at the moment, but what the government have said is that an employer will need to have a reasonable business reason to refuse a request, but what is reasonable is still to be defined. We're also not sure whether or not the existing 8 statutory reasons will remain, whether they'll become something else or whether they'll change. We're still waiting to hear. But what we do know is that employers will have to clearly explain their refusal for writing, which in all honesty I think happens anyway, but potentially it's going to have to be a little bit, you might have to have a bit of a stronger business case as to why it is that you are refusing somebody's request. Another biggie, I guess, is the SSP available for day one. So there is a slight update to this. So the government has already announced that SSP will become available to employees from day one. And they'd previously indicated that they wish to make this available to those on the lowest pay. What they've now suggested is that low paid employees should receive either 80% of their average weekly earnings or the current rate of statutory sick pay, so whichever is the lowest. There is still no date of introduction confirmed for this, so it's still a watch this space, unfortunately. Obviously, the government stated the reason behind their proposed change is that the current SSP arrangements don't encourage people to be off sick, which then can lead to the spread of illness, and presenteeism. So people are in work, but they're not necessarily fully functioning. So they believe that this introduction of SSP from day one will negate that. Banning exploitative 0-hour contracts then. So some companies already utilise 0 hours. We see it quite a lot in the hospitality and retail sector. And the intention with this change is to end one-sided flexibility. So essentially giving workers the security, the predictability, and the right to a contract that reflects their regularly worked hours. So there is going to be a reference period. It is being consulted on, but we expect it to be around 12 weeks. So if generally you use 0-hour contracts for longer than this, you might need to consider using a different type of contract, maybe even like a fixed term contract for a shorter period, for example. What we're hearing is that workers will be entitled to reasonable notice of a change or cancellation of shift, and that the right to compensation will be received if that reasonable notice is not given. We've not had any further information on how it will work. One thing that was asked was whether or not, if a worker refuses that contract or refuses a shift, what that means for employers. We don't know whether or not, if you offer a contract, a fixed term contract or a more permanent contract to a worker, if they refuse, whether, that means that you can continue with a 0-hour contract, or whether or not at a later date you do indeed have to offer a contract. So we're still waiting to hear. The latest update on this particular change, though, is that casual contracts and agency workers will also fall under this change too. So I'm not quite sure how that will interact with the existing agency worker regulations, but I'm sure it will all become clear at the point that this change is introduced. We've then got a further parental and bereavement rights. So the bill proposes to increase rights to all parental leave, and that this is going to be a day one right, where currently it is 26 weeks. So all employees will also be able to take bereavement leave. So some companies, they already pay bereavement leave, which is great. But what we are hearing is that actually it will become the law that they can take bereavement leave, but then also potentially be paid as well. Additionally, who classes as a close family member is going to be kind of defined a little bit more. It's likely to be close family members, but I guess there may well be some discretion in terms of what that looks like. Close family members to one person is different to another, and I guess they need to take that into account. Furthermore, more protection from redundancy and dismissal for pregnant women and mothers returning to work is also going to be introduced. And there are also changes proposed to parental bereavement leave. So an amendment that is being carried through is the expansion of 2 weeks bereavement leave to couples who suffer a miscarriage before 24 weeks. So it's already in place for miscarriages that occur after 24 weeks of gestation. However, this amendment would apply the right to leave for the entire pregnancy period. Okay. And then just, I guess, some other changes to be aware of. So these are actually amendments to the proposed changes that were initially shared in the Employment Rights Bill. So first up is trade unions and the plans to make it easier to join and organise trade unions. So there is going to be various changes to the legislative framework in which trade unions operate. And amendments have been proposed in regards to that. We're hearing that this might include lowering the notice period for staging action. It's going to potentially give the power to government to lower the threshold at which employees can ballot for union recognition, and indeed increase the length of time before a mandate for industrial action expires. So overall, the changes will make it easier for employees to join unions and essentially go on strike and to take part in that industrial action. We've then got the Fair Work Agency. So there isn't much more detail on this at present. All we kind of know is that there is going to be one agency formed that will help to enforce a number of the proposed changes in line with the Employment Rights Bill. We've then got the Fire and Rehire. So the government is proposing changes to the protective awards for failure to consult collectively during redundancies, and ultimately to penalise companies that engage in that whole hire and rehire practice. So they have doubled the maximum period of protective award from 90 days to 180 days. And that protective award actually requires full pay being made to any employee who has been affected. So obviously a cost implication to companies. And then finally, the right to switch off. This is actually a no-go area now. So one change that will not be implemented is the right to switch off. The government has decided to drop this from its plans. Initially, the right to switch off would have made it prohibited for businesses to contact employees outside of their standard working hours. So whilst the government have not ruled it out in the future, it's not actually going to be included in this initial bill and the upcoming changes kind of over the next 12 to 18 months. Okay, so lots to consider, I guess, but in summary, obviously the new duty with regards to sexual harassment is to take those reasonable steps to prevent sexual harassment of employees in the course of their employment. There's obviously the new statutory rates and the increase in NI. There's the introduction of neonatal leave and pay effective from the 6th of April, and then obviously those upcoming changes with effective dates still to be confirmed. So still some areas of grey, unfortunately, but I guess that's where we kind of come in. You know, there may well be some things that, you know, you've absolutely boxed off, you know where you were at with things, you know what you need to do. We may well have spoken to you about kind of, you know, steps to take and whatnot, but there may also be others that you are a little bit more keen to further explore. So we can of course help with everything that we've talked about today. Obviously we look at whether or not you're a HR client. We can do one-off pieces of work to kind of help you get to where you need to be. So of course, if you'd like to talk to us about anything that we've discussed, either drop us a message in the chat box or email us or give us a call or message on LinkedIn, whatever. We're easy to get hold of. But yes, thank you for your time this afternoon. Have we got any questions at all? Feel free to pop them in the chat box. Liz, I don't know if you can see whether or not we've got any. You're also on mute, so if you do say anything, I won't hear you.
Oh, it's very chirpy then. I was like, I can see it, but there's no questions as yet.
No, well, if anybody has got any questions, either pop it in the chat or, as I say, feel free to drop us a message. As Liz said, we will send you a copy of the slides. We'll also send you a recording of this webinar, so you've got it for future reference. If there are no questions, then we'll end the webinar. Thanks for your time and enjoy the rest of your day.
See you later. Bye. Bye.
Bye.
Bye. Bye.